Minister for the clarifications. I think as rightly pointed out, I also personally received a lot of feedbacks. On the ground, people are commenting that the court let go those are breached lightly, and also those that actually can cut off for religious reasons. And worse, they also comment that for this particular case, it was handled by a so-called lawyer who was also an MP from PAP. So may I know what is the minister's stand on this and clarification on this and on these comments, and also what the government can do about all these comments, and also how should we proceed from here? Thanks.
I thank the member for the question. I think Mr. Edwin Tong would not be entirely happy to be called a so-called lawyer and MP. I said I think he is a qualified lawyer and a senior counsel. I said earlier that it's entirely legitimate to express one's unhappiness about court decisions. But some statements have indeed gone too far, abusing the judges personally, ascribing improper ulterior motives to their decision. And it's a clear case of abusing the anonymity of the net, or anonymity to the extent that it exists. Just because you don't agree with the judges doesn't mean that you have the right to abuse them and challenge their integrity. People who abuse judges, challenge their integrity, will be prosecuted if a case for contempt can be made out. I will set out later some factors which would be relevant in this context. The courts should not be pressured by public opinion. They should be free to decide in accordance with what they believe the law to be. Criminal cases must be tried in a court of law, not in the court of public opinion. A few years ago, I had already expected that there would be more and more of such scurrilous attacks on the judiciary. If left alone, they will become the norm. That is why we legislated into law the Administration of Justice Act. One of those opposing it, I think it was Mr. Pereira, asked me in this House, why the need for this law? This is one relatively small illustration. If we do nothing, it will get much worse and become unsolvable. We don't want to end up like the United Kingdom, where the press freely attacks the judiciary. You get newspaper headlines, screaming banner headlines, labeling judges as enemies of the people, you fools, because the courts had the temerity to decide in a way that the media did not like. If we are not careful, we will easily go down that route. Let me give members a current example. There is a public Facebook group with a Chinese name, which I understand can be translated as a policy discussion forum. I was informed that a copy of a news article was posted on the 2nd of February last week on this Facebook. The article had appeared in the Chinese news daily Wanpao on the same day. It was a report on the CHC matter. The title of the news article is a banner headlines had, however, been faked in the Facebook post. The original title translated was, and I quote, "Outdated law saved the accused from harsher penalties." Someone appears to have faked the title into, and I quote, "PAP lawyer saved the accused from harsher penalties," making it look as if a mass circulation newspaper had done so, probably to give more credence to the headline. AGC takes a view that the suggestion from the fake title is that the PAP MP was responsible for an unfair, unjust outcome, and the courts have let off the defendants lightly because of him. AGC's view is that this is a case of contempt by scandalizing the courts. I don't want to go into the meanings of the fake title because the matter is with AGC, and it will be dealt with in accordance with the law. Whatever the meaning of the statement, and regardless of whether or not it is in contempt, one can see that this sort of attack based on deliberate faking is quite unacceptable. I cannot see how any reasonable person will justify such faking as a legitimate expression of free speech. I have asked the police to take a serious view of those who scandalize the court, not only for this case. If there are other comments which cross the threshold and are in contempt of the court, our approach is that action will be taken. That has been so before the AOJP, and it remains so after the AOJP. In coming to a decision whether to prosecute for scandalizing the courts, the factors will include assessing who said it, how seriously is the statement likely to be taken, how wide was the publication, other relevant factors. That's always been the case, even before the AOJP. AGC will assess the various statements that have come to their notice in this context. And quite apart from whether the fake headlines scandalize the court, there is another point. Defendants are entitled to get a lawyer of their choice. Rule of law, a civilized system of having trials in court, depend, amongst other things, on lawyers being able to act for defendants, whatever offenses the defendants are accused of. As I've said before several times, even a child rapist is entitled to his day in court and to be defended. It doesn't mean that we or the lawyer defending the person approves of child rape. But the defendant has the right to choose a lawyer to defend him, and we must not take that away from him. Lawyers should not be made to feel that they'll be hounded online if they take up cases. Let me share a personal example with members. From practice, when I was in practice, I am probably in the unique position in Singapore of someone who has both acted for the 3 prime ministers of Singapore and also of having acted against all 3 of them. In 1995, PM Goh, SM Lee, and DPM Lee, as they were then, sued the International Herald Tribune for libel. The IHT came to me. The conversation as to whether I will act for them took about 2 minutes. I told them they must know I was a PAP MP. Were they comfortable that they will get the best possible advice from me, given my position? They knew that I was an MP, PAP MP. They said it was okay with them if it was okay with me. It was okay with me. I didn't see any need to clear with the party or anyone connected to the party or government. By taking on the case, I was simply doing my professional duty. I didn't need to take on the brief. I was very busy with other work, but I thought the IHT had a right to counsel of its choice. They were faced, obviously, with particularly formidable plaintiffs who could get counsel of their choice, and so I should help the IHT. The import of my acting for the IHT, and it went to court, did not escape Senior Minister Lee Kuan Yew. In court, after his evidence was over, and before he stepped out of the witness box, he said he had to point out the situation. He said that I was close to the 3 of them, meaning the Prime Minister, Senior Minister, and Deputy Prime Minister. I was a PAP MP. The decision by the IHT, despite this situation, to instruct me was, and I quote, the highest tribute to the integrity of the council and, quote, possibly reflected also on the integrity of the government. Over the years, I have also acted for various others whose conduct will not be approved of by the general public, and some of whom were impecunious and could not pay fees. I acted for them whenever I could, based on certain principles which I do not need to go into here. The fake headline that I referred to earlier in the Facebook page is part of a mob mentality to hound lawyers, to intimidate them into not acting in cases which the mob disapproves of. It's quite shameful. Supposing no action is taken, when public Facebook pages do this, then what is there to prevent the media itself from publishing such articles in the future? Supposing by action here, I don't necessarily just mean contempt action. If we accept such faking as normal, then you can see that the line between that and the current position in the UK almost disappears. You will then get in the mainstream media the headlines I earlier spoke about judges abusing them, other similar sorts of things. We should not get there, and it'll be a sad day for Singapore if we do get there. Thank you, sir.